I remember we were in the elevator at our first office, and we were jumping up and down because we thought like $110,000 verdict on that case was massive. And we're like, oh, we're gonna get so much street cred in this community.
Funny,
and we didn't.
Yeah. A cop came up to Mr. Roby, asked him to get up. He didn't want to move. He was resisting arrest, did a somersault off of some stairs, and he had to get dragged like 150 feet to a cop car.
And what about you, Adam? Why did you go to the public defender's office?
I was just following wherever you were working, Michael. Starting a firm is kind of scary, right? I mean, we had no prior experience working at a private firm. I think we could do that. I don't think it's this impossible black box that we can't figure out.
I've never been screamed at more times than when I'm talking to a civil defense attorney, especially if you sue a big person or company. Like they will yell at you. And Elliot, who do you like? You've tried a lot of cases with me, and then you've also tried a lot of cases with Adam. Who do you prefer trying cases with?
Let's be honest, though.
Yeah, that's like me saying, which daughter do I like most?
Well, there's clearly one.
Yeah. Which one is that?
Same question.
Yeah.
Elliot, will you tell us, law school and why you wanted to become a lawyer?
Yeah, I mean, I didn't really know that I wanted to become an attorney, but then a friend of mine was doing trial team out in Orange County at Chapman. He brought me to a trial competition. I watched it, fell in love with it, and said, hey, I want to go to law school so I could do that. And then I remember really wanting to try to make it onto the trial team at Southwestern. And then once I got onto that, like that became my life. Like that's my sole focus. That's all I wanted to do. And I felt like that was where I had the most fun. Those are the people that became my friends, and we were all love doing trial team and doing the trials. So I think that was like the starting point of like just focusing on the art of trial advocacy, because like I had so much fun doing that and just doing it with my peers.
What was the difference between trial advocacy in law school versus doing real life trials now?
Well, trial ad, I felt like in law school was more like for show, right? Like the judges are looking at how we present. We have a limited fact pattern, so we can't go outside those facts. Like we try to make it as real life as possible, but it's like very limited because we have such a, we're looking at four corners of like the facts that we're dealing with. So it was more about presentation, but I thought it was a good foundation for having skills to do things like cross-examination and opening, because you realize really quickly that there's a lot of difficulties just getting up and being able to speak. We're not used to doing that. Nobody teaches us that in law school. So trial ad was like the basis for getting comfortable, being able to do examinations, and just like really feeling comfortable with yourself when you're doing things off the cuff sometimes.
What do you say that like trial team in law school was the best thing you ever did to prepare to become a trial lawyer?
Oh, 100%. If I didn't do trial team and I just went out, got my bar card, and I started practicing, and somebody said, hey, do a trial for the first time.
Different game.
That would be, I would feel very uncomfortable doing that. But having, being in a high stress environment, doing trial team, going against other schools, traveling across the country, and like being judged on the fact pattern, like I felt like that was a really, really good foundation for just being confident, just walking into a courtroom and just being able to be confident in a courtroom. Trial team was definitely helpful.
Awesome. What about you, Adam? Why did you go to law school?
Good question, Michael. Well, your story was inspirational. Mine, I tried every other major, and then I just happened to be like, well, none of those worked out. What can I do with what I learned? I was like, law school's a great alternative. I didn't anticipate being a lawyer, but then I got an internship at court, walked in there, saw the DAs and the public defenders, and I saw a trial, and I was like, this is way more exciting than anything else I've seen so far. So I was like, I think that's a good route to go. And then once I got in it, it proved to be like the best fit, challenging, stressful, hard, but also really fulfilling. I feel like you don't get that sense of satisfaction unless you do something really difficult and hard, right? And so I feel like trial and, trial work is very stressful, but when you do it right and you win, like there's no better feeling,
Mm-hmm. Yeah, I feel the same way. I mean, I always wanted to be a criminal defense attorney, especially like growing up in the 90s and seeing all of these criminal cases on trial. Like, that's what I wanted to do. And then, that's how I started my legal careers in criminal defense. I wanted to ask you guys about like your transition from law school. We all worked at the public defender's office for about 5 years. Elliot, why did you go to the PD's office?
Yeah, so at Southwestern, my school, everybody on my trial team wanted to be a DA. I remember one of the adjuncts that we had, and then we had somebody that was like second in command at the DA's office. Everybody on my trial team was like, I'm going to become a prosecutor. They wanted to intern for that office. And I interned at the DA's office. And I remember thinking, I'm going to get fired from this place if I end up here. But no, my adjunct, who actually, she passed away a couple of years ago. It was really sad. But she was like, why don't you go try working for the federal defenders? I'm like, the public defender's office? She's like, with the personality that you have and the way that you are, she's like, I think that you'd be a better fit at the federal defender's office. So she helped me get into the federal defenders. I'm so happy that she did.
What do you think she meant by better fit?
I have no,
speculate. Michael, you have any speculations as to what she meant by better fit?
No.
Yeah, I have no idea. I don't know why she thought I'd be a better fit there. But yeah, I'm so happy that she did, because when I went there, it was like the firm was great. Like, it's just like everybody had great personality. It was a lot of fun. It was crazy cases. And actually, that's what planted the seed in me finding out about Spence Trial Lawyers College, which for us, it's like one of the most important things from the very beginning. I remember watching a bank robbery trial, and this guy that was going up against two AUSAs, and like just watching his closing, I said, there's something different about this person compared to all the federal defenders. And then so, of course, I sought him out and asked him about his training. And then he's the first person that told me about Spence College. So.
Oh, awesome. And what about you, Adam? Why did you go to the public defender's office?
I was just following wherever you were working, Michael. That was really my main goal. Well, we had a great time. I mean, we went to law school together, and then we ended up interning at the public defender's office. I mean, I would venture to say there was no more fun of a place to work than the public defender's office. If you're talking about the personalities, the people, like the good-heartedness, like really nice people trying to help other people in a super fun environment. I mean, it was tough, right? Like it was a lot of work, difficult types of cases, difficult clientele. But as far as the people that we worked with and how much fun we had, I mean, I was pretty drawn to it. I still think there was no better first job that you and I could have had, and probably Elliot, other than the public defender's office. It's a combination of stress, excitement, and like kind of human drama that makes it super fun.
So what was one of the most interesting cases you tried at the public defender's office?
You start to forget all the cases that you've done because you have so many cases at the public defender's office. But there was one case where my client was selling a bunch of drugs to undercover cops, right? You're not supposed to do that. Well, you're not supposed to sell drugs, but you definitely don't want to get caught by an undercover cop. And so, but it turned out that the reason he was kind of selling the drugs was because his ex-girlfriend needed money for her kids, and he had been out of the game for a while, so he didn't really want to get back into the drug world, but he did it to try to help her. But she was an informant for the undercover cops. So I was like, you know what? You always hear about the entrapment defense. You know, there's been movies about it, but like no one's ever ran an entrapment defense. I mean, have you ever ran an entrapment defense, right? No. I mean, the situations don't arise that often. And I was like, this feels like I could do an entrapment defense, you know, and try to make it seem like the undercover cops were persuading the informant to pressure him to sell drugs. And in exchange, there might have been some sex along the way, right? So I was like, this sounds like an entrapment, and it worked, right? And midway through the trial, the DA, she didn't have any idea what I was doing until like, I'd say 3/4 of the way through, she's like, are you going for the entrapment defense? I was like, I don't know, maybe. And it worked.
So what was from what I know, it's difficult to get the jury instruction where the judge gives you the entrapment defense, right? Isn't it hard to provide evidence to get the entrapment defense?
It is. But I mean, once you meet a certain threshold, it's not like unbearably high, but there was enough facts in there, and through the cross-examination of the cops, and especially through the cross-examination of the informant, meaning the girlfriend who was asking him to sell drugs. I mean, they gave her free rein to do some stuff, right? And like, So I got a lot through her, and the judge was like, yeah, that's, you've met the burden, you can have the instruction. And the jury kind of agreed with it. It also helped that my client was really, he was like credible in the sense he's like, yeah, I sold the drugs, but I was out of the game. I mean, he was kind of telling it. Yeah. I mean, you kind of have to have the client testify in an entrapment defense, you know? But it was wild because I still don't know anybody else who's ran that type of defense.
That's awesome. What was the verdict?
Not guilty.
Awesome.
Okay, good.
Yeah. Guilty.
He's in prison right now?
Yeah. I don't know what happened to him.
Elliot, what about you? Like, what's the most interesting or the biggest case that you tried, like something that you look back on?
Well, I mean, that manslaughter case that I tried right before I left was probably like the biggest case. But that one's probably the toughest one too, because like the guy's Navy corpsman, he's being charged with manslaughter, and I believed him. You know, like it was like one of the few times that like I'm talking to my client, I'm having like this personal talk with him about everything that's happened, and everything that he's telling me, I 100% believe. He just seems like such a credible person, a good human being, and he's a Navy corpsman who's being charged with this, you know, essentially killing somebody for hitting them with a vehicle at night. So that was really tough for me because it's just like we feel all this pressure on the civil side when we're trying cases, and at the end of the day, we are talking about money damages. But there's something about the weight and the pressure of like somebody facing that type of criminal charge. It's like, it's just a different level of pressure. And so like that was like the first time I really, really felt that. And that wasn't my first manslaughter case. That wasn't like my first murder charge. But the other thing too is that, you know, I was able to go and hunt down the main reporting investigator in that case that did all the background and basically looked at how the crash happened and reconstructed the crash. And he worked for Oceanside Police Department. And when I tracked that guy down at his home with my investigator, one of the first things that he told me was, oh yeah, I think that your client's innocent.
How often have you heard that before?
I've never heard that from a police officer on a pending case. So like hearing that the main reporting officer thought that my client was innocent, I had never heard that. You know, I should be knowing that, you know, hearing that information, but hearing that from the main police officer who's doing the investigation for the case, and me knowing that this case is going forward and the guy's life is like on the line, that was a lot of weight.
And what was your defense to that case?
So the client, his story was he was driving home and he was extremely tired that night because he had been on some crazy shifts with the military. And when he was driving, he fell asleep. When he fell asleep, he said that he woke up, the only thing that he saw was a light pole. So in his mind, he looks at his car, he's like, oh, I hit a light pole. So then he ends up going down the street, turning around in a cul-de-sac, and then finding his way to the freeway and leaving. Never did he imagine that he had hit somebody that was riding a bike in the middle of the night. And so his defense was the fact that when he woke up after falling asleep, he thought that he hit a light pole, and never in his wildest dreams did he think that he actually hit somebody that was on a bike, and then the decedent ended up on a part of the sidewalk that you could not see because there was shadows, a tree kind of casting the shadow onto the sidewalk, so you couldn't see anything.
And you had like a lighting expert to talk about how like the human eye and the visibility and the darkness and the contrast and stuff like that, right?
Yeah, I had a human factors expert that came that basically recreated the movement of the bicyclist going down the street, the contrast of the lighting that was there, because there was one street light that was shining light onto the relevant area, but there was a tree that was casting this crazy shadow onto the street. So he was able to talk about the bicyclist in all black shoes, black beanie, had nothing on him, black clothes, I think he had like a Black and Mild and like some AirPods. That's it.
Have you ever felt as stressed about any other case than you did, or maybe not stressed, but just the weight of what was on your shoulders to make sure that you won for that client? Have you ever felt that since then? Like that level?
No case to this day, no case has felt like that. You know, knowing that I'm going to go into closing argument, knowing that, you know, if he's found guilty, he could be sentenced by this judge. Like, nothing's felt like that. Like, I've never physically felt that way going into a closing argument.
Mike, what was your heaviest case that, like, maybe not the most serious case, but the one that you felt the most invested in, that you were, you know, that you really wanted to win for the client, where you were kind of feeling stressed about?
I don't know. I like look back at the PD's office, and I always think about the cases that like were a ton of fun. And for me, the fun cases were just the crazy fact patterns where the clients just want to go to trial. And I think the nice thing about like my experience at the PD's office was we have a client that wants to go to trial, and we have attorneys that want to get trial experience. So at that time, we were all competing against each other to kind of see who could knock out the most trials, who could get the most amount of wins. And I remember trying some crazy fact patterns where I'm still like, you know, I have friends from the prosecution's office. I tried this one case where this guy was in a Santa Claus outfit on Christmas Day on the corner of a street. He was with his pants down, jerking off, and everybody was honking and calling the police. I think there was 6 phone calls. So he was charged with sex offenses. They wanted him to register as a sex offender for life. And at that time, the rule was like, if they want that and they're not going to come off the registration for life charge, then we're going to trial and we're going to argue whatever we're going to argue and try to win. And that's a case that I did against this one guy. I don't want to say his name, but we became very close friends after.
That's awesome.
Well, wait, hold up. What was the argument that you went to trial with?
So that one, I think it was that he was also high on meth at the time. So they charged him with, you know, under the influence of methamphetamines, and then plus the sex charge. So I basically said he was so high that he couldn't establish the specific intent to know what he was actually doing. And yeah, it was a back and forth case. The jury actually hung on that charge, and found him guilty on the under the influence of meth.
Fine.
Which is what we argued was find him guilty on the meth, but don't find him guilty on the sex charge. And this way you could avoid the registration. So that one, and luckily the judge, this judge, a lot of people have criticism towards, but she actually dismissed the case based off the hang.
Oh,
so
that's great.
Sentenced him on the meth charge, and it was fair. And yeah, like those are the kind of the ones that I laugh about with friends and prosecutors that we've tried. So it's all those like wacky cases that you have to present these fact patterns that are crazy, and you have to find an angle. And
that's what's so good about that office is that like you just can't get that type of experience, and you can't have the ability to learn and then try cases like that if you're not at the public defender's office. You can't do that as a prosecutor, right? Like I remember one of the most first like fun case I've ever had. You guys remember Occupy San Diego? Mm-hmm. Remember the whole Occupy movement where people were like
Wall
camping?
Street thing?
Yeah, like they were camping out everywhere. I remember this guy, Jan Roby, old veteran, like handlebar mustache, long white hair. You can like, you know, just like this kind of wacky guy, but it was Occupy San Diego. It was all in front of the city attorney's office. People were camping out in tents everywhere. And the allegations were that a cop came up to Mr. Roby, asked him to get up. He didn't want to move because they're doing the whole Occupy movement thing. And the cop said that he was resisting arrest, did a somersault off of some stairs, and he had to get dragged like 150 feet to a cop car. And he said, the cop said that he was kicking him while he was being dragged, so he got charged with, obviously, assault police officer and resisting arrest. Those were the allegations. There's cops all over the place, so I subpoenaed like 20 cops to trial. And I won't name our supervisor, but at that time, I remember like, you know, second in command and superiors were all like, why is Elliot Jung subpoenaing like 20 cops to this trial on this stupid case?
Just making friends wherever you go, man.
Yeah. I said, no, it's a subpoena. Like they're potential witnesses, and so they're going to come. So I'm calling all these different cops before the trial, and I'm like, hey, did you see anything? Did you see anything? Did you see anything? Everyone is like, I didn't see anything. So nobody wants anything to do with this case. They're all saying we didn't see anything. So we go to the trial. My client gets on the stand, testifies. I never kicked him. When he told me to stand up, I stood up, put my hands behind my back. I got handcuffed and I walked to the cop car. Done. The cop comes and testifies. Mr. Roby resisting arrest, does a somersault. I had to drag him. Then the prosecutor calls another cop. And I'm like, wait, I know that cop. He was on the list. I called him. He said that I didn't see anything. So I'm like, why is he calling him to the stand? So he calls him, and then the cop takes the stand, and the prosecutor's like, well, please tell us what you saw. Like, do you recognize that defendant? He's like, I do. Tell us what you saw. He's like, yeah, Mr. Roby was sitting there. Officer so-and-so asked him to get up. He got up, put his hands behind his back, and then they walked to the patrol car. So that cop that the prosecutor called basically said exactly what my client had said. So my client was found not guilty. I have no idea to this day why that prosecutor would have called that other cop. But I'm like, why in the world would you call this cop if he's going to support our theory of the case? But yeah, I remember coming back to the office, everybody cheering because it was like this crazy Occupy San Diego case.
Well, tell us about, I remember that one case where you're cross-examining that police officer with the flashlight.
Oh, yeah. It was this officer, you know, we all had our issues, like how many cops have we had to cross-examine? You know, it's like the school of cross-examination by having to cross-examine a cop. But I remember this officer was giving me a really hard time on the stand, didn't like me, was fighting with me. And he was trying to say that he had a flashlight in between his armpit and that was shining into the cop car so he could see that my client was looking inebriated. I said, oh, you were talking to him with your hands free and your flashlight underneath your armpit like that? Show us. And I saw a water bottle on the table in front of him. So I said, here, grab this, use it as if it's a flashlight. Show us how you did that. When he grabbed, this is mid-trial, when he grabs that water bottle, puts it in his armpit, the cap just comes undone and water just dumps all over him.
Oh, I love that.
And now he's just furious with me, you know? And I'm like, I swear I didn't know that cap was loose.
What did the prosecutor object to?
Oh, man, what was the word? Sabotage. Objection. Sabotage. I was like, that's not an objection. But yeah, I felt bad.
Was that one of your first jury trials?
It was probably one of my first couple ones, yeah.
Okay. And how many trials did you do at the PD's office? Like, how many trials are you at right now total?
I think right now I'm at 56. So I think I got about 49 at the PD's.
Okay. And what, you went to the Jerry Spence Trial Lawyers College. We all did.
Yeah.
What made you want to go to that college?
Well, like I said, when I was in law school, I was interning at the Federal Defenders. I saw...
well, actually, you know, what is the Jerry Spence College?
Why don't you tell us?
A lot of people might not even know what it is, Michael. So what...
Yeah, go ahead, Adam.
No, go ahead.
So the Spence College is a college. It's a 3.5 week training in Wyoming. You go to this trial lawyer named Jerry Spence, who I think is one of the best trial lawyers of all time. So he created this school for plaintiffs' attorneys and criminal defense attorneys and criminal defense attorneys to teach them how to try cases. So like at 1 week, they'll fly in a professional actor that will work on presentation alone. They also have some of the best trial lawyers from across the nation that will come in each week, and they'll teach skills, opening statement, cross-examination, voir dire. But they really hone down on like telling the human story. Like, how do you present to a jury? How do you show emotional facts to make them actually move? So it is a lot of, you work on yourself, you work on what you're good at, what you're bad at, how can you improve the storytelling process? So that's kind of a background about the Spence College. But what year did you go, Elliot?
2015.
Okay.
So 2015.
We went 2016, so we went the year after.
That's right.
Adam, what did you learn? Like, what was your favorite part of the Spence College?
I think when they teach how to storytell in law school, right, they're very matter of fact about it, and they have like a certain formula that you're supposed to do, you know, kind of past tense or passive voice. Like, this happened, and then this happened, and then this happened to Samantha. But I feel like the Gary Spence with the actors that they brought in and like the different techniques that they did, you're doing a lot more active first person storytelling, right? Like you're setting the scenes, you're actually engaging in the activities that you're describing. So you're telling the story first person while you're actually doing the motion. Just trying to make it a lot more sensory rich, I guess, to try to get the viewer or the listener to feel like they're actually there with you, So instead of just telling them what happened in past tense, you want to bring them in real life, real time. And it just makes it much more fascinating. It makes it more real. And but it's hard to do, right? I mean, it's very uncomfortable. I mean, one of the things that they had us do there to get comfortable being uncomfortable, right, was like singing a song on top of a table. It sounds silly, but like all humans are like nervous and don't want to be made fun of and feel silly, right? And so to be able to do that stuff and do it well, like you kind of have to break down that barrier. And I think they did a really good job doing that.
Yeah. And Elliot, what about you? Like for storytelling, what did you learn specific to storytelling?
I think the component of like, I know people say it's like kind of like, the woo-saw stuff, but like the feeling part was really important for me. I feel like we look at a case, it's very sterile. It's like a fact pattern. We're looking at what somebody's gone through and it's just factual. But like honing in on the feeling of the case for me became important. For example, I remember we were in the chicken coop, so part of the ranch, and there's a bunch of my friends now, my colleagues that were all, sitting against a wall, 2 rows, and I was with one of my now mentors, and he was like, I want you to do a closing argument. And I said, okay, so I had brought another manslaughter case there to work on, and so I started doing my closing in a manslaughter case. And then, 20 seconds in, he's like, stop doing it. And I remember him telling me, you're just doing what you always do. And I was like, no, I'm not. I'm doing my closing for my manslaughter case. And then so he said, hey, let's take a walk. Let's take a walk in a circle and let's start talking about a time that you felt betrayed. And I was like, I don't want to do this. I don't want to jump into this, personal story of this feeling of the time that I felt betrayed. But it was an exercise. So I did it with him. And so through this exercise, I did get down into that feeling of a time that I felt betrayed. And then when I was really in that feeling, he turned me around and he said, now do your closing on behalf of your client with that feeling of betrayal, because that's what this story is all about. And so I did that. I don't remember what I said. It wasn't canned. It wasn't stuff that I'd memorized, but I really did that story based on that feeling of betrayal. I don't even remember what I said, but what I do remember is that at the very end of that closing, I don't cry. Like, I'm generally not a person that has tears, but like for whatever reason, I felt the emotion of tears. And so I couldn't see out of my glasses. So I took off my glasses and I wiped my eyes for a moment. And then I looked at all of my peers. Almost every single guy in that audience, it was mostly guys, was crying. And so at that point I was like, man, I've never like done this before. I've never like tried to do this in any of my cases. And so like that was like the first spark of like, this is something different and special. And so when I went back to the PD's office, I started doing that with all my inmates, going to the DL and try doing these exercises with them. But no, it was a lot of fun.
That's awesome. Yeah, I like look back at most attorneys. I think that they tell a story with past tense. The man walked into the park and he grabbed the child, and then he threw him in the car and blah, whatever. Like that's like a past tense way that normal people tell stories. But I think like, learning that you first set the scene and you say, it's Sunday afternoon, April 3rd, 2018, and, it's San Diego at Kate Sessions Park. You smell fresh cut grass when you walk in, and all of a sudden there was a car that pulls up and this man wearing all black gets out of the car and he starts walking. There's little kids playing in the park and they're laughing and they're throwing balls or whatever around. And this man starts walking up and and then he reaches in his pocket. And, so you add facts to the story of what's happening, and people, you'll see it with the jurors, they'll start to get scared. Like they'll start to feel the anxiety when you tell like a detailed present tense story. And you notice it a lot with comedians. So like I watch a ton of comedians for, mostly because like I want to learn how they're telling stories. They're the best storytellers. Everybody's just listening to every word they say. And it's because they tell a present tense story. So it's a lot of stuff we use actually in trial for trial technique is that type of presentation. And it goes with everything. Like, don't use adjectives when you're speaking about things. So like normal people would say, oh, there was a beautiful fountain. But, the way that we do it is we say, oh, there's a 10-foot tall white fountain in the middle of the park, and, water falls from the to the second trellis and then on to the third, and there's purple and yellow flowers around it. And the audience should see the beauty in their mind and say, oh, wow, that's beautiful. So they make that leap. And, we could do that with anything. We could do it with fear, with, betrayal, or, which I thought was amazing and like kind of things I've learned over the years. But the one, like my favorite thing that I learned throughout a lot of the trainings that I've done is don't make the case about your client and, oh, they're a victim and what are these injuries worth? Or if you're, a criminal defense attorney, make it about, oh, your client's innocent. And like, it's more about like prosecuting somebody for their wrongdoing and putting the concentration on actually like, what somebody did, what they should have done, what they should, like, you have to get the jurors upset and angry to make the move. And you actually look at, the Johnny Cochran and the OJ case. Like he didn't make it about, oh, OJ's innocent, OJ. Like he made it strictly about, are you going to like let this racist cop get away with this and the whole police department that's been doing this for years? So he got the jurors angry at, what they did. And that was the concentration where they're like, no, I'm not going to give you this verdict. So I think even with our injury cases, like,
that's all we do.
That's
all we do. And it's the world of a difference. Like it makes such a difference when you find that villain or you make the jury angry about something. Like it arouses emotion. You're like, we all get angry about things. If someone screws someone over, like it's natural to want to get angry about something where there's like righteous indignation. I mean, we talk about it all the time. Like, where are we going to find the villain in this story? Or like, where are we going to find something that jurors are going to be really angry that happened, and not about our client, about someone else did. Yeah.
Yeah. I mean, we even with like let's say a negligence car accident case where somebody gets injured in a car accident. It was clearly not that person's fault. Like, it's their fault, but it was an accident. They didn't mean to do it on purpose. Like, how do you find a villain in that story? Can you think of any examples that you've done?
Yeah, like one of my favorite ones is I remember we were all brainstorming this case. It was just a car crash case. It was like a city dump truck that, barely hit our client. The crash was decent, but it wasn't like something. The car was turning, so it was like low speed impact.
We made it seem bigger than low speed, but yeah.
But I just remember thinking like, what are we going to do with this case? It's just like another car crash case. We're going to trial on it. Like, how are we, like you said, how are we going to prosecute this case? Like, how are we going to make it into something where, like, I want the jurors fighting for my client? And then we found it. It's because the defense attorneys were trying to bury information in regards to our client's health. Like, literally bury that information by trying to hide a witness, which was their big mess up. And
it was their own expert that saw our client and said, hey, yeah, I think your injuries were caused by the crash, but they didn't want to bring that up in trial. So
they wanted to bury it. Yeah. They literally did not, their own expert that they hired who evaluated our client was stating an opinion that was supporting our theory. And the defense attorney said, you know what, we're still going to go to trial, but we're just not going to call this person. We're not going to subpoena him. We're going to make it seem like he's on our witness list, but we're not going to call him. Thank God that we subpoenaed him. And our intention was to call him just in case, because I had a feeling they weren't going to call him. And they did exactly that. They kept pushing us along and acting like they might call him. And then right before the end of our case in chief, we said, we're calling your doctor because we don't know if you are. And so they made that mistake. And the whole case was about them bearing the information.
Well, I mean, and in the same case, they also followed around our client for years, secretly videotaping him to see if they can trip him up, right? Because he had real injuries, but they wanted to try to show like, oh, you can still live your life. So they would follow him around for years, like in his private home, outside of his front yard, walking his dogs, like super invasive, right? Really creepy. So all of a sudden, this boring car accident case that, I mean, it's a boring case, right? It's just a car accident. He had some injuries. That's it. Now we're getting the jury so angry that the city or a government is spending their time, money to hire investigators to be creepy, follow around our client for years, and at the same time they're hiding evidence. So like all of a sudden it sounds sexier, you know, like it sounds juicier.
Oh, yeah. It's so much better for us.
And you get to make the, like in closing argument, you got to make the argument that like imagine if they spent this level of investigation that they did following our client around for years, actually training their employees on how to drive safely.
Yeah.
Like we wouldn't be here today. Yeah. And it's like it's funny because that becomes the concentration of our closing arguments on how do we prosecute the villain and how do we pull out the villain story. And sometimes it's really hard to find, and it's just writing down. Like the thing that I do in every case is I have a separate notepad that every time the defense attorney tries to deceive the jury, they try to hide a fact, and I got to show, oh, that's not the complete truth. I write it down. And then in my closing or rebuttal, I don't want to say because I don't want to give any defense attorneys, what strategy, but I bring it up about every time the attorney tried to deceive them. And it just like pisses the jurors off and they light them up in the verdicts. And it's like, and everyone oversteps and they all over argue and they say things in opening that are not completely true or not coming out. So
they can't help it.
They literally can't help just putting on a simple, honest case. And like once I meet that attorney, like I'm going to have some serious issues.
Yeah.
But on the flip side too, like what you utilize to really help our cases and make a really good closing argument, we have to be careful too of not saying things that are partial truths, that are exaggerations. So I feel like in general, we tend to be a little more conservative with what we're saying and, kind of under promise, over deliver kind of stuff. Right.
So important.
And I think that's like what from the public defender's office, what I really learned was how to frame issues and how to deal with bad facts. It's like you're dealing with, you're a guy that's on camera for robbing a store, with a gun, and you're going through defenses and saying, well, how do I win this? Like you're looking at every element, you're looking at every word, and you're analyzing what's the angle, like how do I figure this out? So now in these plaintiffs' cases where we get to pick and choose our cases, like the bad facts really aren't that bad. And when you know how to frame them correctly and figure out, okay, I could present this first in this manner, and the jurors won't latch onto it if I don't present it first. So I think getting ahead of them has helped a lot. But I mean, what I wanted to ask you guys. So Adam, why did you want to start a PI firm? What was your purpose?
That's a good question. I mean, starting a firm is kind of like, it's kind of scary, right? I mean, we had no prior experience working at a private firm, working for any sort of private law-related endeavor. So it was completely unknown. But I think the first thing that I was really lucky to is I found two good partners, right? Like we got to go together and we got to start something together. And I feel like, I don't know if I would have done it if it was just me, right? I mean, I think I might have been at the public defenders or maybe did something else. But I really think after seeing these attorneys from across the country at the Jerry Spence College and seeing what types of cases they did and seeing what sort of verdicts they got, I was like, I think we could do that. I don't think it's this impossible black box that we can't figure out. Like there's ways to figure this out, and let's do it. And I honestly just always wanted to try to do new types of cases. And I also just wanted to create our own thing. I always wanted to create our own law firm with our own rules, do it the way that we wanted to do it. And I mean, it was kind of exciting. And I think one thing too is at the public defenders or a DA or at any job that what is going to happen in the future, right? You know what you're going to be doing today, tomorrow, and in 3 weeks. It's not that I was bored of what I was doing. It's just that I wanted some unknowns. Right. I wanted to tackle different things, not necessarily maybe just law related, but maybe business and maybe marketing. And I feel like it kind of opened up more boxes in your head, more avenues that you had to kind of stretch and learn and grow.
Yeah. What about you, Elliot?
I think it was harder for me just because I thought that I was going to be a PD for life. Like I felt like I was a lifer. I loved the work that I was doing. Like I felt like this was my path to like do these trials for clients that needed the representation. But when you guys came up to me after I went to the Spence College and you introduced that idea of starting a business, I also thought about how my cases, my back was against the wall all the time. We know our cases on the defense side. It's like, we got like no facts. Our cases are terrible. We're doing what you were talking about, always trying to like frame a case, figure out how to like deal with this case. And then I'm seeing all these other plaintiffs' attorneys complaining about their one little bad fact or one little issue. And I'm like, man, if I can do an opening or a closing, if I could do a rebuttal, we never get the last word. If I could do a rebuttal on my cases, man, how would that feel? How would that feel being able to do it on the A side where I can tell the victim's story? So that was like that little nugget of like curiosity of what I wanted to try. But it was, you know, a little bit more difficult for me because Adam, you didn't have any kids at the time. I already had a young daughter. I had my second daughter that like was just born.
Right before we opened.
Yeah, right before we opened. You know, like you have the pension and the retirement set up.
All the safety nets.
All the safety net.
All those
and like,
things.
You know, your medical is going to be taken care of for your family, for the insurance. So that part was difficult because like, you know, we've never run a business. You guys have never run a business. Like I didn't know if we could achieve that, but I thought at the same time, if there was ever a time that I needed to do this, it was when
your kids only needed milk.
Yeah,
from your wife. Yeah, that makes sense.
We had like no furniture in my house.
Looking back, it makes sense.
Yeah, so it's like it was a good time. And plus, like I said, we wanted the pressure. You know, maybe not you guys, but I wanted the pressure of like, okay, I have to make this work because my family's relying on me. So,
and this was 2018, March 2018. I remember we opened up the firm, and I think the one thing was we were advertising ourselves as a personal injury firm off the bat. That's the types of cases we wanted to take on. It's so there was a learning curve because you go from criminal defense to personal injury. You know, can you tell us a little bit about what that was like, Adam?
Yeah, I mean, you remember as well as I do. We were calling ourselves a personal injury firm. Yeah, it was a lie. Because we had never done a personal injury case before, but I say it's a lie, but we had the skills that are required to achieve results. We just didn't know about like the specifics, like civil litigation and stuff like that. But the learning curve was steep, right? Everything took 10 times longer. I mean, I still remember in the early days when something as simple as sending a letter out to an insurance company sounds simple. Like I spent 6 hours trying to find the address. Like I didn't know where to send a letter to, right? So I mean, there's these huge learning curves and just the process of civil litigation and dealing with civil attorneys and their personalities. Like it was a big learning curve, but the good news is that like we took on enough cases early on in litigation that we kind of just drank from a fire hose, you know what I mean? And I feel like each of us had a specific case that was really intense that really taught us personally, okay, this is how you do civil litigation. You know?
Yeah, it's funny because I look back at, you know, a lot of people complain, oh, the prosecutors, they're, you know, so harsh, they're rude, whatever. And like when you compare them to the civil defense attorneys, like it seems like the prosecutors are so peaceful and kind.
Yeah. So nice.
Like I've never been screamed at more times than when I'm talking to a civil defense attorney, especially if you sue a big person or company.
Celebrity company.
Like, they will yell at you. And I remember like the first time getting screamed at. And I was just like, oh, I guess this is how it is, like in the civil defense world, like, you know, it's normal. So,
well, you know what, but that's a good point. How many times, I mean, I feel like you, because you had such interesting cases, got yelled at a lot by a number of quote unquote high-powered attorneys, right? Like, but like how often did other law firms tell us like, you guys don't know what you're doing, and like yelling at it and being aggressive, saying you're going to screw your client over, we're going to come after your client, you guys are out of your depth. I mean, how many times did that happen to you?
Yeah, I mean, that happened all the time. And the fact is the cases are all the same. Like you're presenting the client's story and you have certain elements that you can look up that you have to prove. You know, if it's negligence, here's what the elements I have to prove, 1, 2, and 3. And how do I gather these facts to prove that? Just like in any criminal case with, you know, they have to prove battery, the three elements. So everything was the exact same except for the civil procedure. So luckily from early on, we got an all-star paralegal that, would run the civil procedure, would run filing, deadlines, everything. And we also had a lot of resources with the Spence College and good friends that would kind of guide us with some of the procedural issues. But I remember, I think it was our first year or our second year, you guys tried our first civil case. So a firm brought us on, now our very good friends. But Elliot, will you tell us kind of about that first jury trial that you did on the civil side?
Yeah, I mean, we didn't have any, I had no bearing as to what the injuries are, like the medicine, like we had to learn all that. But I just remember it was just a decent car crash. Property damage wasn't too crazy. She had done some chiropractic treatment because she had some back pain. And then I think she got one set of injections. But outside of that, there was like no other treatment. And what we learned is, I'm learning about all this stuff for the first time, the medicine and physiology and everything, is that in an MRI scan that she has a 1.5 millimeter disc herniation, and which we know is essentially,
not large.
Yeah, essentially nothing.
Yeah.
But I just remember, talking to one of our colleagues who's in civil practice, and he was like, "Oh, I heard that you guys are trying your first case." I said, "Yeah." And he's like, "What's the injuries?" I said, "It's a 1.5 millimeter disc herniation." And he just like starts laughing. I'm like, why is that so fun? Like, why are you laughing about that? I'm like, dude, her disc is herniated 1.5 millimeters. Like, this is life-changing. Stop laughing. So we really love the client. We had Judge Sturgeon, who's absolutely fantastic.
We prepped it like a murder case.
Yeah, we prepped it like a murder case.
What was the offer on that one?
I mean, it was like $4,000 in meds, and they're probably not going to give more than $15,000. Not even that. I don't even think.
I think it was the opposite. I think there was about like $12,000 in meds, and the offer was $4,000.
Yeah, it was
that's what it was.
Yeah. Something like almost nothing.
Yep, that's what it was.
Yeah.
But I'll never forget Sturgeon saying at the very beginning of the trial, "You guys need to show each other your slides for opening," and Adam was going to do opening, and I'm like, "Oh, here we go." And so we're sharing the slides, and I have the defense attorney hovering over my shoulder, looking through the slides. And this is the first time that he's going to be able to see how much we're going to be asking for. And he sees that, and he's like, "Wait, that's what you're asking for in this case?" I said, "Yeah, John, that's a slide." He's like, No. That is how much you're asking for in this case." I said, "Yes, John, these are the slides." Like, I remember he was like dumbfounded that we were asking that. And so, at the end of the trial,
how much, what was on the slide?
I think it was 230.
Yeah.
230.
I think 230,000.
Yeah, 230. The jury returns a verdict of 110. And I remember I just wanted to run out there and talk to the jury before they left. And so Adam stayed in there. And then after I talked to the jury, I come back in, and the judge is there, and the judge looks at me and goes, "Mr. Jung, I know you're disappointed about that verdict. Like, I know you're just disappointed." And inside, I'm like, "What are you talking about? We just got a verdict of 110,000.
Yeah, we thought we hit the lotto.
Yeah, we thought we hit millions of dollars." And he goes, "For what you guys had, that was a fantastic outcome." And I'm like, we're just happy. But I'll just never forget, me and Adam walking back to the office, you meeting, literally, it was like serendipity, you meeting at the same time. And we literally hugged each other, looking at each other like, man, we could do this. It was like affirmation, like, we can do this.
Okay, David, cut that part out. Yeah. I remember we
hugged each other, kissed each other.
We were in the elevator. I remember we were in the elevator at our first office, and we were jumping up and down because we thought like $110,000 verdict on that case was massive.
Yeah.
And we're like, oh, we're gonna get so much street cred in this community, but. Yeah,
but it was funny.
And we didn't. Because no one cares about a 1.5 millimeter $100,000 verdict.
Yeah.
But I mean, that case, and most people, they would have resolved it for 10 grand. You know what I mean?
Yeah.
So, we didn't have much options to get to trial without that case. And I'm grateful that our friend sent us a case, because otherwise we wouldn't have been in there.
Yeah, it's still one of my favorite stories.
Yeah. And what about, the growth of the law firm? Like, what types of cases, what's your favorite type of case to take on, Elliot?
I mean, I've always liked trying to do, like you guys know, I love doing the employment cases. My first client was an employment case. I went through absolute hell on that first employment case. That was the first time that I had a sanctions motion for $500,000 with my name on it because of
wait, let's be clear, with HHJ's name on it.
No, I think it was my name. My name was on there. Yeah, it was Elliot Jung on the motion for $500,000. Yeah, which was a failed anti-SLAPP motion. So I love the employment law cases just because I feel like there are some righteous cases, and that was like one of our first like 7-figure resolutions, like early on, and that was my first client. But trying the case, like I like how we haven't like pigeonholed ourselves into just doing auto cases. Whether it's a products case, it's a sexual assault case, it's a med mal case, it's a insurance bad faith case. Like, I like how we have been able to just use our skill set to figure out solutions on these different types of cases because we just like telling the story, right?
Yeah. And what about you, Adam? What are your favorite cases?
I think the sexual abuse cases are really righteous. If you can find one where you can actually really help the victim and go after a big entity, I mean, they're just so easy to get behind. It's so clearly that something terrible has happened, and it feels really good to be able to go after the individuals or the entities that enabled that to happen. But I also like, personally, I like working with the experts and doing directs with technical experts. I always find that fun too.
Yeah, I think, having a nice mix of cases, like I think the auto cases are kind of our bread and butter of what pay the bills, but like trying an auto case is never going to be as fun as trying, like we tried that therapist abuse sex case, and it's like that fact pattern is so much more fun to present to a jury, than somebody that was rear-ended in a car accident and it was an accident. But yeah, I think having the mix is like what makes it interesting and fun, and we get to pick what cases we want to take, and even there's cases that make us a lot of money and there's cases that we take that don't make us a lot of money, but it's the right thing to do. So having a mix of everything is awesome. And one of the things I really like is we don't have to charge people. Just like at the PD's office, we didn't charge clients for our representation, and just like in personal injury, like we don't charge people up front, so we could kind of get a mix of every type of personality across the board.
Yeah, it's like I just did a 7-week breach of fiduciary duty case, breach of contract case.
Completely different than
like completely
else.
Different, but gosh, I mean, that was, look at all the facts that I had in that case, all the fun stories and things that came up in that case. Like, that was pretty wild to have that type of case. I've never handled breach of fiduciary duty, but that was an absolute fun trial.
And Elliot, who do you like? You've tried a lot of cases with me, and then you've also tried a lot of cases with Adam. Who do you prefer trying cases with, and why?
That's like me talking about,
let's be honest, though.
Yeah, that's like me saying, which daughter do I like most?
Well, there's clearly one.
Yeah. Which one is that?
Same question.
Yeah. No, I think it's fun because it changes it up, right? Like, is it different styles? I know you guys have different strengths and skill sets. Maybe one day we'll all get to try a case together. I think that would be really fun. Like on some bigger case, if we're all three of us.
Need a big table.
Yeah, that's true. But I think it's just different, It's different having to stay in a hotel with you compared to having to stay in a hotel with Adam. It's a different flavor.
Yeah, well,
I didn't hear an answer.
Yeah.
Did you hear an answer? Yeah.
Yeah.
We're going to pin you down.
Yeah. With you, I have the pina coladas. With you, I don't. So it's like, it depends on what we're doing.
Yeah, I remember our last trial. I was in trial in San Bernardino for 6 weeks, and you were in trial for 7 weeks, and it was at the same time. And I remember Adam just taking like a zillion phone calls a day for 2 months. And
I was thinking, one of you better win big, because this is a lot of work. I like running the firm with 3 people.
Yeah.
Good thing you got an $18 million verdict, and good thing you had a serious case that was broadcast across the whole community. So worth it. It was worth it.
Awesome.
But to answer your question for him, he likes trying cases with me better.
But that's not true. Elliot, can you give us a closing quote?
I guess the closing quote would just have to be, you gotta want to succeed as bad as you want to breathe. No, I'm not going to use that.
Elliot's always, I just threw that up last minute, but Elliot's specialty is coming up with analogies on the fly.
That always work.
And that never work, and that are always like awkward.
No, I guess the closing quote would just be that I appreciate you guys. I'm so happy that we got to do this. I'm really looking forward to doing this more, other stories that come out, and other people in our firm and outside of our community that we could talk to. But it's been fun, man.
What's your closing quote, Michael?
I don't know. I think that, the goal with this would be to provide some kind of insight on strategy and things that we've learned over the years, and have young attorneys out there that can find it valuable. And I know there's a lot of law students that may look at it and maybe, how do we pick a jury, or how do we do an opening statement? What's like different types of ways to do each of those things? So I think just kind of giving insight on how we do it and what our thing is. And if somebody thinks it's a great idea, or they're like, oh, I know another way to do it that I think it could be better, like, hopefully we can just, bring that to the community, and, it'll also help grow the firm. So
that's awesome.
Yeah. Yeah. I mean, war stories aside, like, there are certain things that we learn the hard way that we can help and expedite the learning curve. Like, there are certain things that you can do that really help your cases right off the bat, and so I feel like it'd be useful to make sure we can kind of bring those up.
Yeah, for sure. And I mean, every case we do focus groups, and we talk to other lawyers, and we say, what do you think about this? Or how would you present this bad fact? And like, how would you do this? And getting reactions from people when you're just putting the facts towards them has been super helpful for us.
Oh yeah.
So yeah, I think, there's a lot of great lawyers in this community, that we've grown with. So
that's awesome.
Should be fun.
Very cool, you guys.
All right. Well, I think that's it, and we'll see you all next time.